All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
Thank you, Madam Court Officer. Now I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office.
Good morning, Your Honor, and to all attending this status conference, both in court and remotely. Appearing for the Specialist Prosecutor's Office today are Alex Whiting, Deputy Specialist Prosecutor, James Patch, Associate Prosecutor, Line Pedersen, Case and Evidence Manager, and I am Valeria Bolici, Prosecutor with the SPO.
Thank you, Madam Prosecutor. Now let me turn to the defense, starting with Mr. Rees, please. Mr. Rees, your microphone is mute.
Good morning, Your Honour. This is Jonathan Rees, counsel for Mr. Gucati, assisted by co-counsel Mr. Hugh Bowden.
Thank you very much, Mr. Rees. Mr. Cadman, please.
Good morning, Your Honour. Toby Cadman for Mr. Haradinaj, joined by Mr. Carl Buckley, co-counsel for Mr. Haradinaj.
Thank you, Mr. Cadman. And for the record, I am Nicholas Guillou, pretrial judge for this case. Before we proceed with our agenda today, I remind the parties that should anyone attending the status conference via video conference experience any technical difficulties, please inform the court officer and myself immediately by waving your hand. And if the connection with any of the remote participants fails, we will do our best to reconnect immediately. If the issue cannot be resolved immediately, I may have to adjourn for the hearing for a couple of minutes to ensure that the line is reconnected. On 17 February, I scheduled the second status conference for this case. My goal today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss disclosure, the status of the specialist prosecutor's investigations and scheduling of his pretrial brief, the points of agreement on matters of law and fact, the status of the defense investigations, the anticipated transmission of the case file pursuant to Rule 72(1) of the rules, when would the parties expect to be ready for trial, and setting a calendar for further steps before transmitting the case file. I thank the SPO and the defense for their written submissions. There is no need to repeat those submissions in detail, but I will invite the parties to respond to each other's written submissions in a concise fashion, following each item on the agenda, which I will address individually. I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Before we start, I would like to address a number of preliminary matters. First, I take note of the application submitted on 23 February by the Haradinaj defense to hold the status conference in the absence of his client, as stated also in the annexed declaration by Mr. Haradinaj. I note that this is in conformity with Rule 96(2)(c), and I instruct the defense to submit such notices in the future as correspondence with court management, appending the necessary declaration. Second, I take note of the request of the Haradinaj defense for a disclosure of certain information regarding a diplomatic communiqué. I will issue a written decision in this regard, so this topic will not be addressed in today's status conference. If any other parties wishes to respond to the Haradinaj submissions, you are invited to do so in writing by this Friday, 26 February. Third, I will issue the following oral order for reclassification of filings. Further to my order of 4 February 2021 and the SPO submissions of 19 February 21, I hereby order the registrar to reclassify as public F51, dated 19 October 2020, and in relation to the following strictly confidential filings, reclassify as confidential and remove the ex parte marking for Annexes 1 and 2 of filing F50, both dated 15 October 2020, reclassify as confidential and make available only to the Haradinaj defense filing Annex 6 of F50, dated 15 October 2020, reclassify as confidential and make available only to the Gucati defense filing Annex 7 of F50, dated 15 October 2020, reclassify as confidential the following filings: F63, including both annexes, dated 30 October 2020, F74, dated 11 December 2020, Annex 1 of F75, dated 14 December 2020, F85 and its annex, dated 18 December 2020. I further order the defense for Mr. Gucati and the defense for Mr. Haradinaj to file by Friday, 26 February 2021, public redacted versions of their submissions for the status conference, F137 and F138, respectively. These orders also apply to any existing translations of the mentioned filings. I would also like to recall that on 19 February, the SPO disclosed Batch 7 under Rule 1021B and also filed its notice under Rule 1023. On 22 February, I issued a decision regarding the SPO's request of non-disclosure of certain witness contacts. And on 23 February, I issued a decision regarding the disclosure of the document batches seized from the War Veterans Association. Lastly, and before we start, I recall that the preliminary motions filed by Mr. Gucati and Mr. Haradinaj, submitted on 2 and 4 February, respectively, are currently pending determination. Let's now move to the first item in our agenda, which is disclosure. I would like to hear from the prosecution on the progress made in the disclosure of evidentiary material, in particular, in relation to Rule 1021B material. I note that in the SPO submission that disclosure under this rule has been completed through Batch 7 of 19 February, and that additional material under this rule may be disclosed further to third-party requests by 9 April at the latest. In this regard, I invite the prosecution to address two issues raised by the defense: the 10 witnesses mentioned at the first status conference, and the manner in which disclosure took place so far, including the information accompanying the disclosure batches in legal workflow. In relation to Rule 102.2, I note that the SPO does not currently anticipate disclosure under this rule. In relation to Rule 102.3, I take note of the SPO's submissions that following the notice filed on 19 February, additional material under this rule may be disclosed further to third-party requests by 9 April at the latest. In this regard, I invite the SPO to indicate whether this timeline is affected by the decision on the batches seized from the War Veterans Association. I also take note of the defense submissions regarding the scope of the notice under Rule 102.3, and I invite the parties to engage in inter partes discussions on this topic following the timeline set out in the framework decision on disclosure. In particular, any items the defense believe that should be part of the notice should be communicated to the SPO by 5 March, which is also the deadline for seeking access to items already on the list. The SPO should seize me with any disputes as to the materiality of the evidence as provided in the framework decision. In relation to Rule 103 material, I take note of the SPO submissions in this regard, including that further material under this rule may be disclosed further to third-party requests by 9 April at the latest. In relation to Rule 107-108, I take note of the SPO submissions that further requests under these rules may be forthcoming, but that they do not affect the tentative timeline. I also note that the SPO is not in a position to indicate whether protective measures requests would come from the third-party requests. I invite the prosecution to indicate whether any such requests could be submitted by 19 March. And finally, and more generally, I would like to know whether the parties are facing or foresee any difficulties related to the remainder of the disclosure process. Madam Prosecutor, you have the floor. And again, it's not necessary to repeat everything you said in your written submissions that I tried to sum up. I'm sorry if it was a bit long, but focus on the questions and especially on responding to the submissions of the defense. Madam Prosecutor, you have the floor.
Thank you, Your Honor. Starting for the disclosure obligations of the prosecutions under Rule 102.1b, as recalled by the pretrial judge, on the 19th of February, the prosecution discharged all of its disclosure obligation pursuant to these rules. The defense argues that the SPO has not completed its disclosure merely based on the fact that the SPO had transparently shared the intention at the first status conference of undertaking a number of additional witness interviews. The defense submission on this point is, however, ungrounded. In relation to the very limited number of witnesses the SPO has currently determined will be included in its witness list, simply there are no interview transcripts to be disclosed. Essentially, there is no obligation for the SPO to interview all witnesses it intends to call to testify. Nevertheless, as amply anticipated in a number of SPO written submissions, the SPO intends to call to testify authors of declarations that have been already disclosed to the defense pursuant to Rule 102.1b and or Rule 103 of the rules. This should address all of the defense doubts on this point. In relation to the defense submissions concerning the modalities of the disclosure under Rule 102.1b, particularly put forward by the defense for Mr. Haradinaj, I have to note that these submissions appear to be not meaningfully substantiated. First, the disclosure packages do come with an index reflecting year-end numbers, detailed descriptions of each disclosed items, categorization for each item pursuant to Rule 109C categories, and other metadata registered in legal workflow. Upon an informal request from Mr. Haradinaj's defense team, the SPO has reminded the defense that the legal workflow allows any user to automatically generate such indexes in the form of Excel tables for any given disclosure packages. Not only, the SPO has even reminded the defense of the operative steps to generate the index it was looking for, the steps consisting of nothing else than clicking on the relevant icon in legal workflow. Counsel seems unfortunately not to have managed to do so, but the defense difficulties appear to originate on this issue from a scarce familiarity with the electronic platform adopted by this court, which channels all disclosures made by the SPO as prescribed by the rules. The SPO has also suggested to the defense of Mr. Haradinaj that if the SPO technical advice was not satisfactory, it might want to direct any request for assistance to the competent office within the KSC, possibly in order to receive a further legal workflow training. Second, as already submitted at previous status conferences and lately again in writing on the 1st of February 2021, all disclosed items are in fact categorized according to Rule 109C categories in the metadata fields in legal workflow. Again, the claims of the defense for Mr. Haradinaj that such categorization has not been provided is without merit. Third, any defense argument on the timing for the submission of the Rule 109C chart appear to seek to relitigate a matter that has already been ruled upon by the pretrial judge with his decision of 11th of February 2021. These submissions should be dismissed since the defense has provided no arguments warranting reconsideration. The SPO has nothing further to add, if not recalling its own written submissions on this matter and the reasoning underlying the pretrial judge decision. In relation to the next item of the agenda, Rule 102.2, I have nothing to add to the summary that has been provided by the court. And I take note of the instructions provided by the pretrial judge in relation to the defense written submission that appear to seek disclosure for items not included in the list provided by the SPO pursuant to Rule 102.3. That would conclude all required responses in relation to this point. In relation to Rule 103, besides recalling the SPO written submissions as summarized by the pretrial judge, I would like to make just 2 points. In relation to the recent court protective measure decisions, filing number F00136 in particular, the court has ordered the SPO to disclose to the defense a redacted version of certain materials. As subject to disclosure, these items will have to be categorized pursuant to Rule 103 or 102.1b, or the residual category under 102.3. So in relation of this decision, further addition to the three categories might be necessary. I also want to highlight that as indicated in the prosecution written submission, need for further addition to any of these categories might come from the third parties' requests that have been indicated, and also by the investigative work that the SPO will continue in the ordinary course throughout the proceedings, which the SPO does not foresee will impact in any way the conduct of the proceedings. Just to be very clear, the SPO will be in a position to file its pretrial brief and will be ready for trial whether the outstanding third parties' request will be received within the timeline or not. And similarly, the SPO will be ready for trial shortly after the filing of its pretrial brief, regardless of the results of any additional investigative steps that it might to undertake in the interim period. One clarification in relation to the Rule 107 submissions is to be made in light of the most recent court protective measures decisions. In light of this decision, the SPO does not foresee any longer the need to submit requests pursuant to Rule 107. In particular, there is Rule 107 information in the materials to be disclosed pursuant to the court decision with filing number F00136 issued on the 22nd of February. However, the authorized redactions adequately address the matter, which means that further provider approval is not needed to enable disclosure. Similarly, in light of the most recent court decision issued yesterday with filing number F00141, which confirmed that batch 3 is not subject to disclosure, further provider approval for the disclosure of Rule 107 information contained in batch 3 is not required. Additional Rule 108 requests by 19 March 2021 will depend instead, inter alia, on which items from the SPO's Rule 1023 list the defense may seek to have access to. In particular, one of the items in the 1023 list is a near copy of one of the seized items for which protective measures have been granted yesterday. So a protective measure request analogous to the one that has already been granted will have to be requested for this item should the defense seek to have access to it. I believe this concludes all required points to be touched upon in relation to the disclosure item on the agenda. Thank you, Your Honor.
Thank you, Madam Prosecutor. Now I turn to the defense. Mr. Rees, please.
Ronna, can I begin by addressing what was said about the 10 witnesses that were identified by the SPO at the first status conference? It's not entirely clear to me what the SPO is saying. Is it their position that they will not be calling any witnesses at the trial, save for calling the makers of the declarations and their summaries as to the position? Um, could the SPO clarify what their position is, please?
Mr. Rees, if you agree, I will give the floor to Madam Prosecutor immediately so that she can respond to your question now before you continue. Do you agree with that?
Please, thank you.
Madam Prosecutor, that's not what I understood. I didn't understand that, well, from what you said, there is no transcript of previous interview of these witnesses, but you still intend to call them at trial. Is it correct?
It's correct, Your Honor. You understood exactly in the terms that I put it. So there are witnesses that the prosecutor intends to call for trial. These witnesses have not been interviewed. Nevertheless, they have issued declarations that have been included in the Rule 102.1b materials that has already been disclosed to the defense.
Thank you, Madam Prosecutor. Mr. Rees, does it answer your question?
No, the only declarations that have been provided so far are from SPO officers. Is it the case, therefore, that the SPO do not intend to call any witnesses other than SPO officers at the trial?
Madam Prosecutor.
This is the current determination of the Office of the Prosecutor, Your Honor, as clarified twice already. Thank you.
Thank you, Madam Prosecutor. Mr. Rees, you can proceed.
Well, I find that rather extraordinary, I have to say. And it's not how I understood the SPO to be approached in the first status conference, indicating that they were going to conduct witness interviews. It would be surprising if witness interviews were conducted with the SPO officers. I had assumed that the SPO were intended to interview witnesses who claimed, for example, to have been intimidated, and that they would be calling such witnesses to give evidence on that point. But I take it from what Ms. Bellucci has now clarified, the SPO do not intend to call any such evidence.
Madam Prosecutor, do you want to add anything on this?
I already clarified the SPO position in this point. I just take the occasion to suggest that in light of this information, the defense might very well reconsider his planned timeline to carry out defense investigations. Thank you.
We'll move to this topic later in the status conference. But Mr. Rees, on this issue of disclosure, you can
I
continue.
certainly won't be reconsidering the timetable in light of that rather remarkable clarification from the SPO in the context of this prosecution. Contrary to what has been said by the SPO, they have not complied with their disclosure obligations. There is, following Your Honour's rulings yesterday, further material that will have to be disclosed pursuant to both Rule 102.1b, 102.3, and Rule 103. In relation to the Rule 102.3 notice that's been provided, that notice, of course, within the structure of the rules of procedure and evidence, is a fundamental building block in the disclosure process. It is the notice by which the SPO sets out what material that has an impact upon the case, that touches upon the case, is in their possession. Whether or not that material is subsequently to be provided or made available or disclosed to the defense, it is the notice which brings to the defense's attention the material that the SPO has. It has to be complete, and it has to be detailed in the content of the schedule to allow the defense to properly ascertain the nature of the material that's held and properly consider whether it is deemed material to the preparation of the defense. The context of this case, the SPO claims at least, is that some 4,000 documents approximately of a confidential nature that have come from the SPO or its predecessor, the SITF, were improperly disclosed. Those documents, if the SPO is right, if they came from the SPO itself, the SPO is bound to have a very significant amount of material which touches upon, is relevant to, and related to those documents, if they are indeed authentic and confidential. The Rule 1023 schedule that we've been provided with is a wholly inadequate document. It contains some 13 documents only, the description of which is so brief, it gives no real indication as to the content of each of those documents, the relevance of them, and to what extent they may or may not otherwise assist in the preparation of the defence. In relation to that point, I understand Your Honour's direction being that we are to raise these matters further with the SPO by the 5th of March in inter partes correspondence, and if the matter is not resolved, for us then to return the matter for substantive argument before the pretrial judge. We will, of course, follow that direction, but I have to say that I foresee nothing other than having to return to the court in due course to argue about these matters in substance and in real detail, because the approach of the SPO throughout thus far has been dismissive and is suggestive of a prosecution that does not take properly its disclosure obligations, as is perfectly demonstrated by the wholly inadequate, frankly paltry document that's been provided as a Rule 1023 notice. We have already set out in our written submissions at paragraph 6 and 7 a list of some items which must be included in any Rule 1023 notice. They are plain that it is material that must be in the possession of the prosecutor, falls within the definition of Rule 1023 as applied by Article 21(6) of the law, and there can be no doubt whatsoever whether that material is subsequently made available for the defence to see in its entirety, or redacted, or not at all, on the basis that there is a contest as to whether it's material to the preparation of the defence. Such material must be on the Rule 1023 notice, which gives the defence notice of the material in the possession of the Specialist Prosecutor's Office. We see, frankly, only further delay in resolving those matters. We await to see, obviously, the material that will be disclosed pursuant to Your Honour's directions yesterday regarding both contact with witnesses and in relation to the material contained within batches 1, 2, and 3. We obviously can't comment further on what subsequent investigations may flow or be required from disclosure of that material at this stage until we have received it. The SPO itself, in its submissions for the second status conference, raises that there will be further additional items under Rule 1021B, Rule 103, and additions to Rule 1023, the notice that it will make. It also indicates that there will be further material to be disclosed, Rule 107 material. And again, likewise, without any assistance in the written prosecution submissions for a second status conference, we will we must reserve our position as to what impact that further disclosure will have upon our preparations until we have seen it, because there is no indication in the written submissions of the prosecution as to the nature of that material. I'm not sure at this stage, Your Honour, whether Your Honour wishes anything further for me to address on the topic of disclosure. We say, and we submitted this in writing, and what has been said by the SPO today only confirms this. We are at the fledgling stage of dealing with the disclosure process. The absence of a constructive dialogue from the SPO seeking to engage properly and constructively with matters raised by the defence in disclosure indicates to us that whereas we are at the outset of that disclosure process, we can only foresee further difficulties going on trying to deal with a dismissive approach of the SPO. Unless I can assist any further at this stage, Your Honour, those are the submissions I make in conjunction with, of course, the full written submissions that we made on disclosure in filing F00137.
Thank you very much, Mr. Rees. Regarding the scope of the list of Rule 102.3 material, this is correct. I would first like the defense to have a discussion with the SPO so that the SPO can supplement the list or not with the documents that you request. And then according to Rule 103, it is up to the SPO to seize the pretrial judge if they refuse the disclosure of any document, including their inclusion in the 102.3 list. Before I give the floor to Mr. Cadman, is there anything else you want to add generally on the disclosure process? Because I know that some problems have been raised about the, but I think it's in Mr. Cadman's submissions, but on the use of legal workflow and the generation of Excel spreadsheet or any other more general problem. Mr. Rees, and then I'll give the floor to Mr. Cadman.
Yes, I've seen Mr. Cadman's detailed submissions on that point, and I wholeheartedly adopt and support them. If, as the SPO allege, it is so easy to produce a proper schedule to the material as they disclose it, then there's absolutely no reason why the SPO can't prepare that schedule and provide it to the defence when the material is disclosed, and to do that on a rolling basis with each new fresh disclosure. For my part, I certainly have not found it easy to navigate my way through the disclosures as they have been made to us in the absence of a proper index from the SPO. So I adopt the position of Mr. Cadman.
Thank you, Mr. Rees. Mr. Cadman, you have the floor.
Thank you, Your Honour. I think on the points that have already been raised in relation to the first questions of certainly Rule 102.1b and subsequent matters of disclosure, there's nothing further that I could add that Mr. Rees hasn't already stated, which is the joint position of the defence and which is not already contained in our written submissions. So I fully support and endorse his position. I further must express some serious concern as to the absence of any constructive debate and what appears to be a fairly dismissive and condescending attitude by the SPO to date. And so just to bring that to your Honour's attention, that the likelihood is that we will have to come back, because it's unlikely that there will be any constructive debate unless the SPO chooses to adopt a very different position to what has been adopted so far. In terms of the legal workflow, Your Honour, I think the biggest difficulty is compounded by our separation from The Hague at present. It may well be easier to access certain additional tools that legal workflow has when we are actually in The Hague, but accessing it remotely, certainly from my side, has been incredibly difficult in terms of being able to download and access multiple files when we have 379 files that we have to access remotely, that we cannot print, we cannot save those files securely. So those difficulties are encountered, and as Mr. Rees has said, if this system of creating an Excel spreadsheet, which I would like to thank the prosecutor for pointing out in the way that she has, how straightforward it is, and perhaps the defence needs additional training. We have been able to identify how to do that, but that doesn't, certainly from my side, it's not what I would expect from a schedule of evidence in other cases. So whilst it is a useful tool, it certainly doesn't replace what are the obligations placed on the SPO. Your Honour, I don't want to repeat everything that Mr. Rees has said, and certainly I don't want to repeat what's in our written submissions, but I am somewhat surprised by the sudden revelation that the SPO does not intend to call any witness of fact as it now appears. That seems to be quite a departure from their position previously. Obviously, it's a matter for the prosecution as to the case they put on, but it is difficult to understand how, in fact, they're going to prove the charges as they are laid without calling any witnesses of fact. But of course, that's a matter for them. In terms of the two orders that Your Honour has set down on the 22nd and 23rd, obviously we'll need to consider those and consider the extent to which the SBO complies with those orders until we are in a position to identify whether that satisfies, from the defence perspective, the disclosure obligations. And so we may well have to come back once the SBO has responded to those orders in the timeline that Your Honour has set. And Your Honour, just as a final point, you mentioned at the outset the section, or the part 6 disclosure in our written submissions. I take your point that you don't want to hear any oral submissions on that today, and that you intend to issue an order by the end of this week. Your Honour, we may have to submit further written submissions on that in due course, due to events having moved forward since the application was made. But certainly I will respect Your Honour's decision not to raise that in oral submissions today, and certainly I had intended to go into closed session if it was going to be raised today in any event.
Thank you, Mr. Cadman. Regarding legal workflow, I think it's an important point because having worked with legal workflow for several years now, it is a useful tool when you know how it works. And I completely understand that it might not be the easiest, especially from a distance. So I would invite the registry, and especially the Defense Office and the IT section, to provide any assistance, and whether it's in the form of phone call or an online training, I think that would be much appreciated by the Defense Counsel, because the idea of this electronic system is to avoid all the parties having to do all these lists, and it's automatically generated. Basically, the machine replaces the individual here for more expeditiousness and more efficiency. So, Mr. Rees and Mr. Cadman, if you agree, will ask the registry to link up with you so that any improvement can be made if needed, because there might also be some issues with the connections. Because I think it's very important that you have a good access to it, because this is the key for you to get any evidence in the case.
Your Honour, if I may just add one very small addition to that. One of the difficulties that the defence is encountering so far, and I know this is a matter that the registry has raised, and that concerns us having the ability to be able to send documents to our clients who are currently detained, because there is no process for privileged electronic communications with the detention facility. I appreciate that may be something that the the registry will be looking at, but that is also going to hamper our ability to move forward with investigating towards a sensible timeline, being able to take instructions from our clients.
Thank you, Mr. Kedman. Mr. Rees, do you want to add anything?
Only this. Your Honor, I certainly agree that the legal workflow tool is a useful tool and does assist the parties. I have no doubt about that, and no criticism being made of the legal workflow system. What I do suggest is that it would nevertheless still assist if the SPO put some human input into case preparation and provided a index with all material that they disclose. That is not an onerous task, according to Ms. Bellici and the SPO, because they say they have the tools to prepare one simply. The legal workflow system itself, and indeed the registry itself, are not responsible for the prosecution of these cases. The SPO is. And it is not much to ask the SPO to prepare a short index, setting out in a easily referable manner the material that they disclose to us. We can then use that index to very quickly identify the relevant materials on the legal workflow system. That's all that we ask for.
Thank you, Mr. Rees. Madam Court Officer, I invite you to link up with the relevant sections of the registry so that assistance can be provided in the following days to the Council, especially whether there is any improvement possible for the remote legal workflow access and also for any privileged communication between the councils and their clients. I think there's been some improvement done regarding this last point, at least in another case, and I hope this will be able to be done in this case as well. Madam Prosecutor, do you have anything to reply to the defense? Shortly, please.
Yes, very briefly, Your Honor. I just want to put on the record that the SPO firmly rejects any allegation which is generic and unsubstantiated from the defense that the prosecution has adopted a dismissive approach in discharging its disclosure obligation. The SPO has complied with all its disclosure obligation under all relevant rules according to the timeline as set by the pretrial judge in the framework decision. I fail to see which kind of constructive approach the defense wished to seek beyond that. The SPO has received no request whatsoever from the defense in relation to any of the steps undertaken in the course of the disclosure procedure. Besides the request from Mr. Haradinaj to provide the defense with an index, which received a timely explanation by the SPO in relation to the possibility of automatically generating this index, which applies to the defense for Mr. Haradinaj as to any other users of this platform that has been adopted by the court. That is all I need to reply for the moment. Actually, if Your Honor allows one more issue, the defense for Mr. Gucati seems to have misunderstood the prosecution submissions today in relation to disclosure under Rule 102.1b, under Rule 103, and under Rule 102.3, as well as under Rule 107. The defense alleges that it is not clear which kind of additional items will have to be disclosed under these rules. The SPO has made very clear which kind of additional items will have to be disclosed under these rules, both in writing and earlier today, identifying the sources that might determine this additional need. In particular, in relation to the decisions recently issued by the pretrial judge, ordering the prosecution to disclose redacted materials that have been subject to SPO request, the SPO has explained that such materials, as subject to disclosure, will have to be categorized. This is the source of additional materials to be disclosed under each of the relevant rules. I further clarified that there is no further request to be made under Rule 107. So all points made by the defense of Mr. Gucati were based on a total misunderstanding of the prosecution submissions today and in writing.
Thank you, Madam Prosecutor. Unless there is any request to reply, I will move to the second item in our agenda, which is the SPO investigations, submission of the pretrial brief, and the completion of disclosure. In this regard, I take note of the SPO submission that it expects to be in a position to file its pretrial brief and related material, together with its Rule 109C charts, and to complete disclosure under Rule 102, including disclosure resulting from third-party requests, by 9 April 2021. I further note that the SPO submissions that the only outstanding investigative step regards the third-party requests. In this regard, I invite the SPO to indicate whether an estimated date of completion can be provided for the overall amount of evidentiary material. Madam Prosecutor, you have the floor.
Your Honor, as summarized by Your Honor, the SPO expects to be able to conclude all relevant disclosure by the time of the filing of its pretrial brief. As said, we do expect to receive the replies to third parties' requests within the set timeline. Nevertheless, should these replies not be received, this would not impact on the prosecution ability to file a pretrial brief and to be ready for trial shortly thereafter. I also wish to highlight that, as put forward in the written submission, the investigative work of the SPO will continue throughout the proceedings, and 4 additional evidence relevant to this case may be uncovered. In that event, the evidence will be disclosed to the defense as provided and provided to the court pursuant to the applicable provisions. The SPO does not foresee these impacting anyhow the speedy conduct of the proceedings. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense on this topic. Mr. Rees.
Well, all I can add is to reiterate our skepticism that disclosure will be complete by the 9th of April, 2021. We, of course, are still awaiting disclosure under Rule 102.1b, under Rule 103, and we are awaiting resolution of the concerns that we've raised about the Rule 102.3 list, which may itself lead to further disclosure issues once that list is properly prepared in a complete and detailed form. We hear what the SPO says about its claim to be able to serve the pretrial brief by the 9th of April, but we are skeptical as to the assurance that disclosure will be completed by that date for the reasons that I've just set out. It is, of course, only once we receive the further material that it will be forthcoming, and there is proper resolution of the Rule 102.3 list issue that we will be in a better position to assess disclosure going forward.
Thank you, Mr. Rees. Mr. Cadman, please.
So nothing, but you're having nothing further to add that's not in the written submissions, and what Mr. Rees has already said. We have expressed our skepticism throughout the written submissions, and we maintain that position.
Thank you, Mr. Cadman. Then I will move to the next topic in the agenda, which is the points of agreement on matters of law and fact. I note that the parties have not yet entered into discussion regarding the possibility to submit points of agreement on law and/or facts. I also take note of the timeline proposed by the SPO to reach agreement, if any, on such point by 26 March. Any points of law and fact not agreed upon by the deadline shall be left to the determination of the trial panel. On this basis, I would like to hear from the parties whether they can submit a joint filing on any reached agreement by 2nd April at the latest. I also wish to recall that there is no obligation from the parties to agree on matters of law and/or facts before trial. Madam Prosecutor.
Yes, Your Honor. As detailed in the submission for this status conference, the SPO is willing to submit proposed points of agreements to the defense by the 12th of March, so subject to the availability of the defense team to reply to any such submissions by the prosecution. The SPO will be certainly be in a position to file a joint submission by the 2nd of April, as indicated by Your Honor. Thank you.
Thank you, Madam Prosecutor. Mr. Rees.
Your Honour, we will not be able to comply with the timetable that's been proposed. We will still have disclosure outstanding on the timetable as presently put forward, for disclosure to be made by the SPO by the 9th of April. We can't possibly begin entering into discussions about the agreement on points of law and fact in the absence of disclosure being completed. We are, of course, further hindered by the real difficulties we have in our own case preparation at the moment, matters which are set out in detail in both in our written submissions, in paragraphs paragraphs 26 onwards. Your Honour will be familiar, of course, with the difficulties that have been proposed, that have been faced by those in countries with serious coronavirus restrictions on movement and so on. We simply are not in a position to be able to envisage compliance with the timetable on discussions of points of agreement and fact that is being proposed by the SPO. We think it is, again, wholly unrealistic of the SPO to propose that timetable.
Thank you, Mr. Rees. Mr. Cadman.
Your Honour, I would have to reluctantly agree. As Your Honour will see from our written submissions at paragraph 30 onwards, we set out in detail the very real difficulties that we have faced in moving things forward. And as Mr. Rees has said, we can't even begin to make proper preparations until disclosure is complete. And as the current time scale of early April for completion of that. And that's assuming that we don't need to come back due to a lack of constructive dialogue and for potential non-compliance with the 22nd and 23rd of February orders that Your Honour has given. So the timescale that is being proposed, we are not in a position to meet that as things currently stand.
Thank you, Mr. Cadman. Madam Prosecutor, do you want to reply?
Your Honor, very briefly, the defense appears to have misunderstood the SPO submissions on this point. The disclosure has been completed as required by the rule and as directed by the pretrial judge. That's a fact and is not subject to any further assessment. The SPO has clearly highlighted which are the possible, very limited items that might be subject to disclosure should the prosecution get in possession of such items within the deadline set by the court. There is no reason preventing the defense from starting engaging in this case on the merits of this case based on the ample material, the extensive and complete material that has been disclosed to the defense according to the relevant timeline. Besides that, I want to also observe that the defense has been unable to provide an example of failure of constructive attitude on the side of the prosecution. However, the prosecution is now in a position to highlight an example of lack of constructive attitude on the side of the defense. I acknowledge that both defense teams consider that they will not be in a position to engage in considering any point of agreement on matters of law and facts prior to the exchange of the pretrial brief. It appears that such position runs contrary to the goal of ensuring an expedited course of proceedings. All is required to the parties is to consult on possible points of agreement on matters of law and facts, as they might find out through consultation that such points of agreement can already be identified. This would lead in turn to narrow the scope of the litigation, which would ultimately result in saving time, including in the preparation of the defense case. Having acknowledged the defense position, the SPO remains ready anyway to submit points of agreement on law and facts pursuant to Rule 95.3 and 156, according to the court's directions and in the interest of the expeditiousness of proceedings.
Your Honour, I would like to
Thank you, Madam Prosecutor.
respond to that, please.
Mr. Rees, you have the floor.
Your Honour has just seen a perfect example of the dismissive approach of the SPO to its disclosure obligations in this matter. I raised at the first status conference, when there was no obligation on the defence to do so, that there were two specific issues that we asked attention to be directed to. We asked the SPO to direct its attention to identifying all the material held by it, which relates to the origin and provenance of the material contained within batches 1, 2, and 3, including material as to its authorship, chain of custody, from creation to its arrival at the KLA WVA headquarters. The approach, the response to that from the SPO has been wholly dismissive, as demonstrated by the 13-item Rule 1023 list, which is intended to suggest a complete list of all material touching upon this case that the SPO has in its possession. That list itself is perfectly demonstrative of the dismissive approach of the SPO. We also raised at the first status conference, without any obligation on us to do so, but in order to give early notice to the SPO to engage with us and identify relevant material, that we would be looking to establish whether or not the SPO itself played any part in the 3 disclosures to the KLA WVA headquarters, referring in particular to an authority on entrapment, which Mr. Page at the first status conference specifically referred to. Your Honour can assess for Your Honour's self whether the SPO's approach to that has been dismissive or not. We say there has been no engagement by the SPO with the issues that we have raised thus far. And the proposition from Ms. Bellici then, moments ago, that disclosure is complete, runs contrary to the written submissions that the SPO has entered in relation to this very hearing. They have said in their hearing that they would purport to complete disclosure by the 9th of April. And yet at the same time proposed a timetable for discussions on points of agreement on law and fact, which preceded their proposal to complete disclosure by the 9th of April. We will not be bounced by the SPO into these proceedings taking place in an untimely and unseemly haste. We will ask, in accordance with Your Honour's direction, we will seek to have inter-parties correspondence with the SPO prior to the 5th of March to see if there is a willingness on the SPO to engage in the matters that we have raised. We are skeptical as to whether the SPO will, but we will hope that they do. And we will hope that as part of that inter-parties correspondence, we will receive a full and complete Rule 1023 notice, not the wholly inadequate document of some 13 items that has been provided thus far.
Thank you, Mr. Rees. Does anybody want to add anything? No? So, Mr. Cadman. Briefly,
Honor.
please, and really on this issue of points of agreement on law and facts. We're not going to rediscuss about the Rule 103 list. Really on this topic, Mr. Cadman.
No, Your Honor, and I will be very brief. I can only emphasise and support what Your Honor has now seen, what the court has now seen, as the dismissive and condescending attitude that we are faced with. The SVO seems to think that the only obligation on them is to expedite these proceedings, and that is their only obligation. And quite frankly, it is a ridiculous position to take. These proceedings have to be conducted fairly. There has to be equality between the parties, and there is not. And Your Honor will undoubtedly have to rule on many of these issues. And as Mr. Rees has said, the disclosure is not complete. By Your Honour's own rulings in the last few days, and by the SBO's own admission of 9th of April. The SBO needs to be reminded of what their obligations are in this case. It is not for the SBO to railroad the defence, as Mr. Rees has said, into a fast trial. And unfortunately, Your Honour, as attempts will be made to be constructive with the SBO, they need to approach these discussions constructively and sensibly.
Thank you, Mr. Cadman. Very briefly, Mr. Rees, and only if it's related to the topic we're discussing, which is the points of agreements of law and facts. Please, you have the floor.
It is, Your Honour. I'd like to stress this, that we obviously see the advantage to all parties and the trial panel in a constructive discussion in due course, when disclosure has been fully made and when investigations on both sides have been completed, including defence investigations, in having a meaningful discussion to see whether agreement can be reached on points of law or points of fact. That obviously is an important stage in the preparation of a trial that is both fair and runs efficiently. And we wish for that to happen, but that must happen in a timetable that allows the defence the time to conduct its investigations, with disclosure having been properly and fully completed so that the defence are aware of it. And then at that stage, proper discussions taking place so that the trial panel can be presented as far as possible with agreed points of law and fact. That is all we're asking for, is an appropriate timetable to allow that to happen.
Thank you, Mr. Rees. Let me just add a couple of points on this issue of agreements on points of law and facts. First of all, I don't think full disclosure is needed to start the process. You can always agree on points that are very simple, such as the birth date of the accused, for example, or any other very simple matter. I don't think these needs to have the disclosure finalized. So I think this process can at least start. Second, I also want to mention that regardless of the scope of the list of document in Rule 102.3, there is already some material that has been disclosed. You have the Rule 102.1a material that was disclosed with the indictment. There is also some material, Rule 102.1b. There is still a debate on the Rule 102.3, but I think the defense can start this process. Whether it will be totally finalized is another matter, but I think this process can start. And this is what I invite the parties to do with the SPO. I see that there is some tensions between the parties that is apparent in this courtroom. I invite them to, in good faith, discuss with each other, try to get to as much agreement inter partes related to the Rule 103 material, try to engage in good faith again in the agreements and law and facts, and then I will rule on any matter that hasn't been settled, especially regarding the Rule 102.3 material. And finally, regarding the agreements on points of law and facts, this is completely in the hands of the parties. Nobody will force you to make any agreement on this, and if the defense do not want to agree on any points of law or facts, it is absolutely in its right to do so. So really on this is really a tool that is given to the parties to avoid litigating on some matters at trial, but this is absolutely not an obligation. Now, let me move to the next point of the agenda, which is the defense investigations. I would like to first to thank the defense team for their submissions on this matter. And I would like to note that neither defense team is in a position to indicate whether they will request unique investigative measures or give notice of an alibi defense at this stage. I further invite the defense to provide an update on the status of its investigations, and approximately how much time it will need to finalize such investigative activities. Mr. Rees, you have the floor.
Your Honour, we have set out, I hope quite candidly and in some detail, where the defence is in terms of its investigations. We have received some 3,000 pages or so of material since the 4th of January, all of which, save for an almost insignificant amount, has been categorised as evidence that the SPO will be presenting. There is, we estimate, around 100 hours of footage that's been disclosed and categorised as evidence. So a significant amount of material that we have had to begin working our way through since the 4th of January. That material contains the identities of many persons who play a significant role in the events of the indictment. And we will, as we indicated at the first status conference, be looking to fully investigate those events and seek to interview each of the persons that we are able to identify as playing a significant role in those events from the evidence that's been disclosed. We note in passing in the submissions that task of identifying persons who have played a significant role in those events has been made harder by the SPO refusing to particularize the individuals they refer to as, for example, others or certain others or associates or certain parts of the media or certain parts of the public in the indictment. If they had properly particularized it, that would have given us great assistance in that task of identifying relevant other persons. We have to do that task from the material that's been provided to us without the assistance, at the moment at least, of such particulars in the indictment, although, as Your Honour has acknowledged at the outset, there is effectively an application for further and better particulars presently outstanding in the form of the motion relating to defects of the indictment. We have, as Your Honour would expect, got on with the task of analysing that 3,000 pages of evidence and 100 hours of footage. And that has continued as we've been provided with the disclosures. That material didn't all come on the 4th of January. As Your Honour knows, it has come in different stages from that period onwards. At the same time, the UK and the Netherlands have struggled with a huge surge in coronavirus cases. Kosovo itself has continued to see a higher rate of positive COVID tests at any point during the first half of last year when the global outbreak began. In the UK, we have been subject to very severe coronavirus restrictions that have placed real restrictions on movement, both within the UK, but also, of course, importantly for these purposes, internationally. And we anticipate those restrictions will continue for some time. Very recently, the latest position appears to be that the 21st of June is something of a deadline, and it's very unlikely for us to see any changes to international travel restrictions taking place before then. We also understand there are restrictions in Kosovo in terms of a curfew, which also likewise make witness interviews difficult for us to plan at this stage. We nevertheless must carry out those investigations, and we will do so as quickly as we safely and legally can within the international restrictions that have been placed upon us. We have set out in our written submissions what we envisage to be a realistic timetable, and it is the following timetable that we propose. We do so acknowledging that the 9th of April date that is proposed for the prosecution to file its pretrial brief effectively allows the SPO some 4 months from the confirmation of the indictment to prepare its pretrial brief. Your Honour will see that the period that we propose for to allow for us to respond with a defence pretrial brief, and we do intend to file a full and complete pretrial brief, which we hope will be of great assistance to the trial panel and will assist in a fair trial taking place. The timetable that we propose is less than the 4 months that the SPO have had from the confirmation of indictment to prepare its trial brief. We propose, we ask for a timetable given us until the 2nd of July 2021 for the submission of a defence pre-trial brief, which is effectively just short of 3 months from the 9th of April date for the prosecution to file their pre-trial brief. That is assuming that they indeed do comply with that proposal.
Thank you, Mr. Rees. Just one very small question. I think you mentioned, this is what I see in the transcript, the current restrictions for travel were postponed until 21st June. I think you meant 21st March probably.
No, my understanding of the position at the moment is there's no definite date for the lifting of restrictions on international travel in the UK, although they have proposed that the 21st of June as a target date for a more relaxed approach to coronavirus restrictions taking place across the board.
Thank you, Mr. Rees. Mr. Cadman, please.
Your Honour, just to say that the timeline that has been proposed is a joint proposal for both defence teams, and so we support the same timeline. And Your Honour, only to say that in addition to the restrictions that have been imposed, there is also the great difficulty in the availability of flights. As is in our written submissions, we had intended to do a preliminary trip to Kosovo, and the flights were cancelled 24 hours before departure. So it obviously makes it very difficult when flights are being cancelled, as well as the additional restrictions. And if we are able to actually travel to Kosovo, we are then further restricted in having to quarantine when we return to the United Kingdom. So it does put huge difficulties on our ability to move forward effectively. And so we would ask Your Honour to take that into account when considering the proposed timeline.
Thank you, Mr. Cadman. Madam Prosecutor, do you want to add anything?
Yes, very briefly, Your Honor. In relation to the defense reference to the number of items disclosed under Rule 102(1)(b that are considered to be of a size difficult to manage, I just wish to reiterate that of the 379 items in the Rule 102(1)(b list, 132 had already been disclosed to the defense pursuant to Rule 102(1)(a, that is like as indictment supporting materials or in the course of the exculpatory evidence disclosure. So the defense has been in possession of this material not since just a few days ago. Furthermore, 79 of these items are audiovisual items, but 122 are transcripts of these audiovisual items, both in English and in Albanian. The majority of audiovisual items feature statements made by one or both the accused, and as such, their contents is already well known to the accused themselves. The remaining items consist inter alia of reports, news articles, and other evidence obtained from the public domain, including translations of such materials. So given that the items in this residual category are mainly articles in Albanian and screenshots from open source materials, about half of the residual items comprise of translation of such materials. Therefore, 379 items is by no means a large number to begin with, but when considering that much of this number is comprised of translation, then the number of items disclosed to the defense under Rule 102.1b is far lower and appears to be easily manageable. I would like to further stress that there is no reason why investigations are not already underway, considering in particular that the defense has been on notice of the SPO case since the time of the arrest, that indictment supporting material, as recalled by the court, have been disclosed on the 4th of January, and the detailed outline mandated by Rule 86.3 of the rules is available since the 8th of January. Above all, I would like to recall that the scope of this indictment is very limited and identifies 3 key events, the press conferences held by the accused, which constitute the crux of this case and are recorded on tape. On a different point of the defense submission, the SPO has made clear and wishes to reiterate once again that COVID is a real concern and must be taken extremely seriously, and the health and safety of staff, both the SPO and the defense, as well as that of witnesses, comes first. At the same time, by looking at what this institution was able to accomplish in the year of this pandemic, and considering that other defense counsels have already, in fact, begun investigative activities in Kosovo, the SPO respectfully submits that there are steps that can be undertaken, in particular in the specific circumstances of this case, where most of the information disclosed by the SPO has been obtained through open sources, available to the defense in the very same terms as they are available to the SPO, and above all, available worldwide without any need to engage in field missions. In the specific circumstances of this case, where the indictment alleges that the accused have committed crimes through public, recorded appearances, the fact that the defense has declined so far from starting engaging in the preparation of the defense appears hard to be attributed to the pandemic. In relation to this, the proposed timeline for the submission of the defense pre-trial briefs appear to be hardly compatible with the need for an expeditious conduct of the proceedings in light of the points that I just made. Thank you.
Thank you, Madam Prosecutor. Does the defense want to
please, Your Honor.
reply? Mr. Rees, please.
The SPO respond effectively by saying the defence don't need any further time to investigate these matters. They're straightforward. The SPO, of course, are asking for 7 months from the date of arrest to service of their pre-trial brief. We're asking for a period of some 3 months to respond to their pre-trial brief. And we're asking to do so in circumstances where we've made clear from the outset that we intend to investigate issues such as the authenticity and the confidentiality, as alleged, of the material in batches 1, 2, and 3. We do not accept the bold proposition from the SPO that we should take their word for it. And we have made clear from the outset that we intend to investigate the issue as to the circumstances in which those 3 batches came to make their way to the KLA War Veterans Association headquarters. At the moment, the SPO produce no evidence on that point, but we wish to investigate it, and we will investigate it. And we also intend to speak to witnesses who were present at each of the 3 events referred to by Ms. Bellucci. Just pause there. The indictment is not limited to those 3 events whatsoever. The indictment begins by setting out that there was a period of some 6 months in total in which relevant matters were said or done. And the indictment itself, the counts of the indictment, as we understand the SPO's case, are not restricted to the events of the 3 conferences, but also to events taking place in and around those 3 conferences. We intend to speak to other witnesses who were present, who played a part in events, and adduce evidence as to their motivations and their intentions, and to do what the SPO again have announced today that they will not do, which is we will seek to speak to witnesses about consequences, the extent that there were, or importantly were not, the consequences that the prosecution allege in the indictment. So there is a significant amount of investigative work that we intend to do and will do. We have not been able to properly commence that investigative work because of the restrictions that have been placed upon us resulting from the coronavirus global outbreak. We do not have the resources of the Specialist Prosecutor's Office. It's in those circumstances that we say the timetable that we're asking for is both realistic and it is reasonable. We'd ask Your Honour to take those matters firmly into account.
Thank you, Mr. Rees. I don't see anybody else. No, Mr. Cadman, please.
Your Honour, just to re-emphasise the point, the SBO has referred to this being in relation to 3 key events, but Your Honour will be mindful of the fact that the timeline, as Mr. Rees has set out, details some 6 months prior to that. So it's not just a matter of obtaining open source material that we can quickly conduct an investigation and be trial ready. I mean, such a suggestion is quite unrealistic. The other point that the SPO has stated that the material of the 379 items, 132 of them have already been disclosed. That may be the case. We still have to check that because they're not when they're disclosed as part of the disclosure batch. It would be helpful if they are in separate disclosure batches of material already disclosed. So the 132, it would have been helpful if they'd been disclosed as a separate disclosure batch that would actually enable us to do that. The other point is that whilst this may relate to recordings and transcripts and translated transcripts, we have to have those transcripts verified as to whether the translation is accurate. We can't simply just take the SPO's word for the fact that these are sufficient translations. There are, of course, in every language, peculiarities in different dialects. So we have to ensure that what's actually in the transcript actually represents what was stated. So it's not just a matter of taking the transcripts of 3 key events that were public events and preparing an investigation. So I'd ask Your Honour to really take that into account when looking at whether it is realistic to move forward in the expedited manner in which the the SPO is suggesting.
Thank you very much, Mr. Cadman. Before we move to the next item in our agenda, let me just turn to the interpreters. I see that it is now nearly 1 hour and a half since we started. Is it possible that we continue for a further 10 to 15 minutes?
Yes, Your Honor.
The interpreters for their... Let us now move to the last two items in our agenda, which refers to the transmission of the case to the trial panel and when the parties expect to be ready for trial. First, I note the defense submission that it objects to any proposal that this matter be tried by the trial panel consisting of a single judge. In this regard, I remind the defense that any decision on the assignment of a panel is a competence of the president and not the pretrial judge. My prerogative under Rule 72 is simply to transmit the case file to a trial panel assigned by the president. In this regard, I also note that transferring the case file to a trial panel after the disposal of the preliminary motions by the appeals chamber does not mean that the trial would start at the same time. It simply means that the remainder of the pretrial process, including the finalization of defense investigations and filing of their pretrial brief, would be overseen by the trial panel. In light of this, I would like to hear the parties on the transmission of the case file to the trial panel around mid-April 2021, pursuant to Rule 72 of the rules regarding expedited proceedings. Madam Prosecutor.
Thank you, Your Honor. The SPO does not foresee any reason why the case file could not be transmitted to the trial panel as soon as currently pending matters have been resolved, be it mid-April 2021 or even earlier than that. Thank you.
Thank you, Madam Prosecutor. It cannot really be earlier than that unless you file your pretrial brief way earlier than that. I just mentioned that because if we have your pretrial brief on April 9th, it will be impossible to send the case file to the trial panel before that. Let me now turn to the defense. Mr. Rees, please.
Your Honor, it seems to me the starting point is Rule 95 of the rules, which is the, sorry, not Rule 95, my fault, Rule 98, sorry, which deals with transmission of the case file to the trial panel. Rule 98, sub-rule 1, provides for the complete case file to be transmitted from the pretrial judge to the trial panel only after receiving the filings from the specialist prosecutor and the defense pursuant to Rule 95, 4 and 5. That's the rule in relation to pretrial briefs. So Rule 98 provides that in the ordinary case, as it were, the case file will not be transmitted to the trial panel until there has been the exchange of pretrial briefs by prosecution and defense. Rule 72, sub-rule 1, does provide for the possibility of transmitting the case file otherwise than in accordance with Rule 98. So before the exchange of those pretrial briefs, but only where there's an indictment in respect of an offence under Article 15.2, and more importantly for these purposes, where the case file is to be transmitted to a trial panel in accordance with Article 25.2 of the law. It is not a general power to expedite submission of a case file prior to exchange of pre-trial briefs between prosecutor and defence. It is a power that applies only where the case file can be transmitted to a trial panel in accordance with Article 25(2) of the law. Article 25(2) of the law provides that in proceedings in relation to Article 15(2) crimes, which are not classified as serious crimes, under Article 22 of the Kosovo Criminal Procedure Code, law number 04/L-123, the trial panel may consist of a single judge. So a discretion in those circumstances for the trial panel to consist of a single judge, or indeed an usual trial panel under Article 25(1)(b) composed of 3 judges and 1 reserve judge. The discretionary power in that case, a discretionary power mirrored in Rule 72 as to whether there is an expedited transmission of the case file to such a trial panel consisting of a single judge. It seems to me, therefore, that there is a primary decision to be made before considering whether Rule 72 be used. The first decision to be made is whether this matter will be tried by a trial panel consisting of a single judge under Article 25(2), or by a full trial panel under Article 25(1)(b), composing of 3 judges and 1 reserve judge. Now, I acknowledge Your Honour observing that Your Honour's powers do not extend to assignment of trial panels, and that's a matter for the President. In those circumstances, it would be our submission that it's premature to look at whether Rule 72 should be applied or not. The first decision that has to be made before any such consideration can be given is to whether the trial panel will be a single judge or a 3-judge panel. In that respect, we note also that in the directive on the assignment of judges, it is made clear that such questions should be transparent. And as that is a listing decision, it's a discretionary decision, it does not follow that proceedings in relation to an Article 15(2) crime, which is not classified as serious crimes under Article 22 of the Kosovo Criminal Procedure Code, will be or must be tried by a single judge. As it's discretionary, there ought to be a discussion, if necessary, with the President, with submissions being made by the parties on the point, and the President to then rule, having heard argument on the matter, if indeed it is a matter for the President and not for Your Honour as pre-trial judge. I can say this, that our submission as we've put it in writing is that in any event, we would submit, and we have provided an outline of what our submissions would be if there is indeed a proposal that the matter be tried by a trial panel consisting of a single judge. We've set out in writing an indication of what our submissions would be if that situation did arise in paragraphs 39 to 42 of our written submissions. And we do submit that in any event, there is good sense in the organisation of a fair and indeed efficient trial that Rule 98 requires at the point at which transmission to the trial panel takes place, handover document summarising the arguments of the parties, the points of agreement, the evidentiary material produced by each party, suggestions as to the number and relevance of the witnesses to be called, and questions of fact and law that are in dispute. There's good sense in that, and we won't be in a position to be able to do that until after the exchange of not only a pretrial brief by the specialist prosecutor, because that would be one-sided, but after the exchange by certainly the defence for Mr. Gucati, and as Mr. Cadman has made clear, the intention to submit a pretrial brief on behalf of Mr. Haradinaj also. And we have set out submissions as a realistic timetable for that to take place already. Those are my submissions. Unless I can assist Your Honour with any particular point that I've raised there, in particular in relation to the operation of Rule 72 and Article 25(2).
Thank you, Mr. Rees. Mr. Cadman, please.
Thank you, Your Honour. Of course, I don't want to repeat what Mr. Rees has said, and we fully support the position set out on behalf of Mr. Gucati as equally applicable to Mr. Haradinaj. Your Honour, I would say this, and I'm obviously careful not to stray into matters not to be discussed today, but certainly we would hope that a decision has not been made already as to the composition of the trial panel, and that we would have the opportunity to make submissions to the President before any decision is taken for the reasons that Mr. Rees has already stated, of being of critical importance. The only point I would say is that at this stage, it is premature to be making that decision. We have proposed a third status conference to be held early to mid-April. At that stage, a decision can probably be made as to whether it is appropriate to send the matter to a trial panel in whichever form that might be. Your Honour, we've heard the term used repeatedly today, expedited proceedings. I only say this with some concern, is that there appears to be an attempt to rush this forward before we are really ready. Obviously, this impinges upon the rights of the accused, and I would ask Your Honour to take that into account. It's not just that these proceedings should be expedited. These proceedings should be conducted fairly with equality between the parties. That really needs to be the overriding consideration in this, not just rushing forward for the purpose of having a trial before the court. So certainly our position would be it is premature. It should be decided in April as to the appropriate time and the appropriate format or composition of the trial panel.
Thank you very much, Mr. Cadman. Just a couple of things regarding the legal framework. First point, Rule 72(1) specifically mentioned at the end of the paragraph that it is notwithstanding Rule 98(1), so it is an exception to Rule 98(1). The second point I'd like to mention is especially how the system, so to say, works, is that according to Rule 98(3), as pretrial judge, I provide notice to the President. And this is where the powers of the President, according to Article 25(2), that are the powers of the President only, that are not the powers shared with the pretrial judge, of assigning a panel. I just wanted to give this detail about the legal framework that we have between our law and our rules. Madam Prosecutor, is there anything you'd like to add?
No, thank you, Your Honor.
I don't see any hands, so at this point I would like to ask the parties whether they have any other issues they would like to raise. And as usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information so that appropriate measures can be taken. Madam Prosecutor.
Nothing else from the SPO, Your Honor. Thank you.
Thank you, Madam Prosecutor. Mr. Rees.
Only this, Your Honour, in paragraph 46 of our written submissions, we've set out, because we understood the court to ask about when a trial may take place. We have set out a proposed timetable there that we'd ask the court to consider. That takes into account both the ongoing work from the SPO, with a further 6 weeks for them to serve their pre-trial brief, the ongoing disclosure issues that we envisage to take place, defence preparations, and of course, bearing in mind the holiday period that will take up August. So we have proposed there a trial not before the 30th of August 2021. Obviously, that matter can be considered further, we understand, at the next status conference. But just wanted to raise that we have replied to the request for submissions on that point.
Thank you, Mr. Rees. Mr. Cadman, please.
Your Honour, once again, just to confirm that the defence are in line with that same proposal. That is a joint proposal for a realistic timeline for being trial ready.
Thank you, Mr. Cadman. I thank the parties for their submissions. We will now break for 20 minutes and resume the hearing at approximately 1:05 The Hague time. I will issue a couple of oral orders when we're back in session. The hearing is adjourned.
All rise. All rise. Please be seated.
Having heard the parties on the proposed calendar, I will hereby issue 3 oral orders. First, by 9 April 2021, the parties are ordered to notify me by joint submission of any agreement on points of law and fact. Second, by 9 April 2021, the SPO is ordered to file its pretrial brief, witness and exhibits list, as well as its Rule 109C disclosure chart, accessible to the defense. And third, by 9 April 2021, the SPO is ordered to complete its disclosure under Rule 102 and to complete disclosure of any Rule 103 material in its possession. I would now like to ask the parties for their views on a suitable date for the next status conference to address any outstanding matters before the next steps. I would ask all the parties to have in mind the recess of Easter as well when you propose dates, please. Madam Prosecutor.
Thank you, Your Honor. The SPO will be available at the court's convenience and would welcome a status conference to be scheduled in the second half of March. Thank you.
Thank you, Madam Prosecutor. Mr. Rees, please.
I think in our written submissions, Your Honor, we propose the week after Easter.
Thank you, Mr. Rees. Mr. Cadman, please.
Thank you, Your Honour. We've requested the same. Mr. Buckley and I have another trial matter for the first 2 weeks of March, so that would take us out for to at least the 3rd week of March. So I think after Easter, first week of April would probably be the most appropriate.
Thank you very much, Mr. Cadman. You will receive a scheduling order that will include an agenda before the status conference in due course. I also invite the parties to make written submissions if they would like to raise any specific issues during the next status conference. This concludes today's public hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters for their flexibilities, stenographer as well, audiovisual technician, security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.